Do you think that one of the most common rifles in America should not be considered protected by the Second Amendment? Let me know what you think down below. Hello everyone, today I want to talk to you about how a federal court upheld an assault weapon ban and said that assault weapons are not protected by the Second Amendment. It's an interesting one, right? Let's talk about it, but before we do, I do want to say thank you to the sponsor of today's video, Bullet Safe. If you are interested in body armor, specifically soft body armor vests, they're a great way to get a hold of those. If you live in the state of New York, this might be particularly interesting to you because bullet vests were actually the only body armor that were banned in the state of New York. I believe that goes into effect in less than 30 days, so if that's something you're interested in, I highly recommend you check it out. Lots of stuff that's actually NIJ approved. I very much appreciate their support. Thank you to Bullet Safe. So the title of this headline that I saw is Assault Weapons Not Protected by Second Amendment, Federal Appeals Court Rules. And this was a 10-4 ruling in the Fourth Circuit Court of Appeals. Now, the basics of how this went down is Maryland has an assault weapon ban that bans a variety of different types of firearms. Basically, the most popular assault weapon style firearms, your ARs, your AKs. I believe Maryland has it banned by name in some instances as well, or as some specific types are banned. Now, assault weapon is a term that a lot of people get really heated when I use, so let's just clarify something real quick. A lot of times when people criticize my use of the word assault weapon, they say there's no such thing as an assault weapon. What they're trying, or they say that's not an assault rifle, that's a semi-auto. Okay, well, assault rifle, assault weapon, two different words, both of which do have meaning, both of them do have definitions. The definitions can vary state by state federally, when it comes to assault weapon, but assault rifle typically means a select fire intermediate cartridge rifle. So since they're not full auto, they aren't assault rifles, you're correct. But when we have to discuss the laws, we have to use the definitions like assault weapon to say that this is maybe an assault weapon, but it doesn't mean that you don't have the right to own it. The Second Amendment is not what gives you a right. The Second Amendment acknowledges your right to arms so that you can protect yourself from both individual threats and from government-based entities that may wish to do you harm in some way. Arms in general. So even if it was an assault rifle, even if they are assault weapons, you still have the right to own them as guaranteed, as acknowledged by the Second Amendment, not granted to you by the Second Amendment. Okay, we got that out of the way. Now, this court case went to the Fourth Circuit. They said, hey, the district court that initially handled it, they did not use a strict enough level of scrutiny. They said you have to use strict scrutiny. The state of Maryland then appealed that up to en banc, meaning a larger panel of judges is then going to look at it in the Fourth Circuit. The Fourth Circuit ruled that the assault weapons are not protected by the Second Amendment. Now, a quote from that ruling was, put simply, we have no power to extend Second Amendment protections to weapons of war, Judge Robert King wrote for the court, adding that the Supreme Court's decision in District of Columbia versus Heller explicitly excluded such coverage, which is interesting because I know at least 4 Supreme Court justices believe that the states with assault weapon bans and various other bans on firearms are not accurately using Heller, so I think this is going to be a very interesting one. We'll see how this one has to play out once New York State Rifle and Pistol Association versus Bruen eventually gets to us, which who knows, might be late June, might be July, we will see. I'm not holding my breath because I will probably die. Now, Maryland Attorney General Brian Frosh, who led the push for the law in 2013 as a state senator, said it's unthinkable that these weapons of war, weapons that caused the carnage in Newtown and other communities across the country, would be protected by the Second Amendment. It's really not unthinkable when you know what the Second Amendment means. People love to say, oh, well-regulated, and militia. Well-regulated at the time meant in good working order, and having the militia was meant to be made up of the people. It's two separate things. The people are who has the right to keep and bear arms so that they can form a militia. Does that kind of make sense? Two separate things. The freedom that's guaranteed, that shall not be infringed, is for the people. Now, Judge William Traxler issued a dissent by concluding that the Second Amendment doesn't even apply. Traxler wrote, the majority has gone to greater lengths than any other court to eviscerate the Judge William Trexler issued a dissent by concluding that the Second Amendment doesn't even apply. Trexler wrote, "The majority has gone to greater lengths than any other court to eviscerate the constitutionally guaranteed right to keep and bear arms." Now, many states, California included, they try to play around it. They don't say that you have no right or that definitely all of these guns are not protected. They say that even though it may infringe upon your right, they are able to infringe upon that right because it's still achieving the goal, or it's intending to achieve the goal of safer cities, safer states, safer country. So the state of California specifically is kind of using like a two-part test where they're saying, hey, look, this does kind of infringe, but you have other options and we have a goal. We want people to be safe. This is basically saying these guns, fuck them, get them out of here. They are not protected by the Second Amendment at all. And that's crazy. That's the most harsh stance that I personally have seen any judgment given on assault weapons. Now, he goes on to continue to say, for a law-abiding citizen who, for whatever reason, chooses to protect his home with a semi-automatic rifle instead of a semi-automatic handgun, Maryland's law clearly imposes a significant burden on the exercise of the right to arm oneself at home, and it should at least be subject to strict scrutiny review before it is allowed to stand. And I think this is really where New York State Rifle and Pistol Association versus Bruen could potentially shine. I know that a lot of people are really hoping that Bruen sets a standard of scrutiny that can be used for all other gun cases going forward. Because currently, like the state of California, a lot of states are just getting by with playing around it using lower levels of scrutiny, just saying, hey, look, we want these laws to work and to stop crime, so that's good enough, right? And that's how they're getting away with it. If strict scrutiny is applied, it wouldn't allow them to play these games in the same way. They can still potentially play games that would affect your right to keep and bear arms. Directly, indirectly, who knows? We will see how that pans out going forward. But if strict scrutiny is applied in Bruen, and Bruen says that this sort of situation has to use strict scrutiny, this could have sweeping impacts on a whole lot of court cases, not just because of concealed carry laws and that kind of thing. It could potentially affect the Second Amendment as a whole, and potentially other rights as well. We will have to see. Now, they spoke to an NRA spokesperson who said it's absurd to hold that the most popular rifle in America is not a protected arm under the Second Amendment. She added that the majority opinion clearly ignores the Supreme Court's guidance from D.C. versus Heller, and that the Second Amendment protects arms that are in common use at the time for lawful purposes like self-defense. Now, they estimated that anywhere from 5 to 10 million AR-15s are owned. I know that the most recent stat, the best guess that we have from, I think, the National Shooting Sports Foundation, is anywhere from like 18 to 20 million AR or AK style firearms are currently in possession. Now, keep in mind, that's only what they can estimate based off what has been sold from a licensed manufacturer. How many people do you know personally? Just think to yourself, you don't necessarily have to comment. How many people do you know that have manufactured a couple 80%? Maybe just one or two. How many people? How many people do you know that maybe you just think about yourself? How many have you done? Again, you don't have to comment these down. Feel free if you want to. The 80% market is massive. There is no way to truly know, but the best estimate is that there's nearly 20 million of the 300 or maybe 400 million firearms currently in possession. That's pretty commonly used, especially considering that they are sold so rapidly and so frequently and so commonly currently. Do you think that one of the most common rifles in America should not be considered protected by the Second Amendment? Let me know what you think down below. You guys know the drill. Have fun, be safe, stay dangerous. Peace.